Well, the Supreme Court has had the world in a tizzy, so to speak. India Inc. and lawyers have been in a state of shock since May 2nd, when the Supreme Court rejected the 4 years ago acquisition of Bhushan Power and Steel by JSW Steel and ordered the liquidation of Bhushan Power. The court has severely pulled up all parties for flouting the bankruptcy rules. It says the resolution professional didn't adhere to the mandatory timelines, did not provide mandatory evidence of the eligibility of the bidders, especially JSW. It has pulled up the bankers, or what you call the committee of creditors, for quietly accepting the delayed payment of the upfront money by the winning bidder, that's JSW Steel. The court has also pulled up JSW Steel for revising the resolution plan with an addendum after it was approved, and for delaying the implementation, what it calls inordinately, by 2 years. The government, on its part, is currently worried that the reversing of an acquisition of a sick plant 4 years after it has been revived very successfully by the acquirer can scare away India Inc. from applying in the future for bankruptcy, for reviving bankruptcy cases. Primarily, it seems a pity that a company whose output has been doubled since its acquisition is again being sent for liquidation. That seems to have taken the entire India Inc. and the legal community and the government by a state of shock. To understand the judgment and its implications, likely future options available to the government, to the bankers and to JSW, I am being joined by a top panel. Joining me are Mr. MS Sahoo, former chairperson of the Insolvency and Bankruptcy Board of India, one of the authors actually of the Bankruptcy Code. Actually, most of my guests are authors of the code. Bahram Vakil, founder partner at AZB and Partners. Nalin S Kohli, senior advocate at the Supreme Court. And Vardhan, a senior advisor at Bain and Company. Gentlemen, thank you very much indeed for your time. Mr. Sahoo, if I may start with you, would you say that, I mean, what are your first comments on this judgment of May 2nd judgment by the Supreme Court?
Yeah, this is absolutely legally sound, but completely economically hollow. This is an economic law. It must embed both economics and law. But it has been a very fact-intensive, detailed, marked with legal precision, exposes a series of irregularities and lapses, and some of them deliberate, some collusive, and in fact, some of them that occurred after the appeal was filed. It has identified a set of people who have been responsible for this, but refrained from issuing any directions, remedial, preventive, penal action against any of them. But it has effectively penalized the company and the broader economy.
Okay, actually, I think that's very nicely summarized, perhaps the point of view which the government is coming with. But let me take it clause by clause. We are first, of course, interested in JSW itself because, they have, even if they have not put in their money, they have put in their time. They have put in money also, 19,700 crores, which will perhaps be returned by the bankers, but you won't get the interest on it. You still lose 3 years of interest on that money. So commercially, that's also questionable. Well, Bahram Vakil, on that point, the winning bidder, JSW, delayed because the ED attached the assets. So do you think that the court is amiss for not looking at that point? If the ED is attached, how will they implement?
Yeah, thanks, Latha. I think that that's a very fair point, that there was some amount of justification in the delay. But I think, Dr. Sahoo has been very generous. I have to be careful in my comments for the court. But I'm not sure that they, it just the balance of the 3 biggest violations that they found, the remedies are not in balance. They are commercially, almost I can use the word absurd. So if I quickly run through the 3 biggest grievances they had, 29A, I think that they could easily have sorted that out by having whoever they wanted to, whether it's the COC, whether it's the RP, whoever, do a further diligence, give a certificate if they were not happy with what was already done. Delay, I mean, again, there are to a fiscal problem, there's a fiscal remedy. You don't have this completely unpractical remedy, of unraveling, as you said, an acquisition 4 years down the road. And also, in some ways, again, with all due respect, the 2 years, arguably because of the ED, you had some justification, but the court takes 4 years. So again, it's a difficult thing to say that you are very upset with the delay. And we all know that there are solutions for delay. I don't want to get into what is the right solution, but there are solutions. If you don't receive money, the normal solution is you charge some kind of fee for the delay. And the last one was the operational creditors, where also there was concern. And again, this could have been fixed, that if you think that the split between FCs and financial and operational was not good, you could have passed an order to that respect. But this was a really drastic and strange decision.
I take your point. This is like, I flout a traffic law, I do some lane cutting or take a wrong turn. The result cannot be death sentence or, taking away my right to drive for life or something like that, which would tantamount to taking away my livelihood. It looks like the punishment is not entirely commensurate with the crime committed. But Harshvardhan, you're kind of an outsider because you're not in the legal community. So what are your thoughts? Is there any of all the faults pointed out by the court, is anything very sanguine, very serious?
Yeah, so I think as Sahoo sir and Mr. Vakil has pointed out that they have laid out clear procedural violations which were either intentionally done or unintentionally done, okay? But I think between the line, there are also some serious strictures against NCLT and NCLAT. And I think I'm hopeful that one of the outcome of this is that there are some reforms to these two tribunals. I mean, we've been arguing that, they need to have higher capacity, greater capability. They deal with complicated commercial issues. So I think that I noted that also, while, it's not sort of direct, but clearly the Supreme Court has come down very heavily on some of the decisions that the appellate tribunal made, and even LCLT made. So I think that's one thing you have to really glean from the order. And so I think as an implication, as you mentioned, this would make future participants in the insolvency process very cautious. Because the remedy just, it's just not excessive in my opinion, but also in many ways impractical. I mean, you have a 25,000 crore revenue asset which is profitable that you are going to put into liquidation. Makes very little sense, to be honest, commercially.
Yes. No, for all you know, it will be bought over by somebody at perhaps double the price. But that's not the point. The point is whether, you have scared away India Inc. and therefore destroyed bankruptcy code in future cases. Nalin Kohli, what would your observations be? One of the big things is delay, which the court has, written a lot about. Who has the right to extend the effective date? And when? Is that, what does the law say and what actually happened? Is there a breach there?
Lathaji, let me give an alternative point of view. First, let's look at the background. The IBC, when it came in, and Mr. Sahoo has been part of that as the architect of that process. When the IBC came in, it recognized that there was a problem with the promoters and there was a problem with keeping the management in the hands of the debtors. So in effect, the IBC reverses the control into the hands of the creditors, in this case, primarily the financial institutions, which becomes the COC or the Committee of Creditors. Second, the IBC was seen to be a resolution process for recovery, not for destruction of assets. The whole idea of the IBC is that the company must be resolved finally to operationalize it as a going concern through the process, and then its resolution through a successful resolution applicant at the end of the process to keep it alive. Liquidation is putting it on the death block. which is per se not the intent of the IBC. It is finally the outcome if the resolution fails. So, I mean, these are critical, fundamental points to bear in mind.
Okay.
Let's move
Mr.
to the
Kohli,
next thing.
1 minute, sir. Sir, 1 minute. I want to ask you, what is the court's role normally? Is the court only to say legal, illegal, or does it have, is it incumbent on the court to take a holistic view of public interest?
So,
How should the court approach it?
You will have to give me the indulgence for another 2 minutes.
Sure, by all
It
means.
must lay down the lay of the land, and I will certainly answer what you're saying. So I made my first point, shift
Yes.
the control of the management
Yes.
from the promoters or the debtors to the creditors.
Yes.
The second point being resolution or its resurrection is the idea, not its death, which is what
Yes.
liquidation in a sense would qualify to be. The third point is to plug the loophole. There was the ordinance route which introduced 29A. And Section 29A of the IBC, in effect, made sure that a promoter cannot continue to come and take over the company in the resolution process, which means it recognizes the promoter is the problem. You have now prevented him or her from coming back and taking the company over through a haircut. So this is the broad principle.
Got
The
it.
fourth is the legal argument, is that what is the scope of an appeal? Because ultimately now we need to look at the Supreme Court judgment in terms of what was before it. So here you have a case, as I see as a lawyer practicing in the court, that the promoter's appeal has got through. The ED, which was responsible for the delay in the process, gave up its appeal in December 2024. So, I mean, I really ask myself that the impediment to the entire process for a long time was the attachment of the assets.
Absolutely.
The provisional attachments stayed by the court, but nevertheless under the threat of an attachment pending, which was why the ED was the worry, and they withdraw in December. So, I mean, in a way, if I look at it from Jindal's point of view, they've given 19,000, some 400-500 crores.
Yes.
The banks have taken the money. The company, as is reported publicly, has doubled its, and you said it also, from I think 2.5 million tons
To 5 million tons.
The number of employees seem to have gone some 2.5 times, from 8,000-9,000
Yes.
to some 20,000, which means this is not just a healthy, but it's a growing asset.
Yes.
Now, at the end of it, I have to ask myself that what have we achieved? Have we undone the code? Number one, are we sending a message that irrespective of what the code and the process of the code does, finally, this process can be turned off, or that entire process can be brought to naught after 7 years? And let's not forget, Bhushan Steel is one of the 12 dirty dozen, which the RBI identified among many others. And basically, it was the first of its kind in the dirty dozen. For these companies, it was very, very new. IBC was young. The process couldn't understand the scale of what had to be done. Here you are talking of thousands of crores.
Yes.
And therefore, handling it had to be time consuming. Now, finally, the role of the courts. Now, this is critical because this will bring up the point, what are the next steps? Now, I really can't speak for what the government would decide, or the affected party being Jindal, who have invested the money in that sense and are now left with a situation where the asset is threatened under a liquidation process, or the banks. The government is as one, as the upholder, what the economic activity should be. The banks as the people who have received that money, which is ultimately public fund. And then a question will arise that ultimately whose appeal has succeeded?
Yeah.
The appeal of the ex-promoter, whom the entire process is geared up at.
Oh, 1 minute. Mr. Kohli, I should hold you on that. Actually, even the ex-promoter has not succeeded. He has only succeeded in thwarting the acquirer from acquiring, but he cannot acquire in any case. So I won't say he has succeeded, but clearly everybody has lost. In the process, the economy has lost. And actually, the court is a little upset that people are presenting them with a fait accompli, to be fair to them. You're so convincing in your arguments as to the early teething troubles of the bankruptcy process. I'm surprised the court was not convinced by what you said. At least I am. But I have to take a commercial break, sir. I'm coming back and going to ask my experts, what are the options going forward? We have what we have, but now we have to try and do the best for the economy. Those questions after the break.